Well, the courts are being dominated by some high-profile political cases right now. Judgment is expected today in Jacob Zuma's application to stay his arrest, even though he's already in prison, and his constitutional court case to rescind his 15-month sentence is being heard on Monday. Meanwhile, a ruling is also set to be handed down today in Ace Makashule's bid to be reinstated in the ANC. It's a lot for the legal system to contemplate right now, so we've roped in Dan Mafora from the Council for the Advancement of the SA Constitution to help us dissect the big issues. Dan, thanks so much for joining us. Let's just start with Ace Makashule's case. This was really a matter that put the ANC's internal processes and its own constitution on trial, right?
Absolutely. So the question essentially is about the relationship between the party and its members. And Ace Makashule made some very interesting arguments around the constitutionality of internal party constitutions. And so today we will see whether or not the court will nullify the rule under which he was suspended, or whether or not the court will find that his constitutional rights were not really affected by the actions taken by the ANC within its constitution.
Let's move to Zuma's case, where we're expecting judgment today in the Pietermaritzburg High Court. The urgent interdict, which was heard earlier this week, is it null and void or moot now that the applicant, Jacob Zuma, has already been arrested or incarcerated?
So that's a very good question, and I think the answer to that is yes, because obviously you can interdict something before it happens, and since the order that was sought to be stayed in this case has been implemented, it seems unlikely that a court would grant the stay. But even then, there are obviously other legal questions about whether or not the stay or the court is able to stay it or would be able to stay it if it still hadn't been implemented.
The big Constitutional Court case on Monday, Dan, for rescission, which is really just legalese for set aside. The test for rescission is quite high. I'm just looking at some of the reasons why you would set aside a case if it was erroneously granted, common to parties. For instance, if Jacob Zuma had been tried in absentia, if there was an ambiguous or patent omission or error, or if the order granted was an absolute clear mistake. Do any of these tests apply, in your mind, to the Constitutional Court finding Jacob Zuma in contempt?
So on the facts, and given how this case has proceeded, in my opinion, in my view, this case doesn't meet any of those rescission bases. So Mr. Zuma, in his papers, makes very interesting arguments about possible constitutional errors committed by the court and by the commission in bringing this the case for direct access. And so it seems that he is making an argument for an expansion or a development of the rules relating to rescission, because I think it is also clear that this is not a normal case that would fall within the current rules.
Thanks so much, Dan Mafora, who is at Casac. And just to be clear, the acting Chief Justice, Raymond Zondo, who's also hearing the Zondo Commission, will, of course, recuse himself from the case. And he will, I'm sure he won't sit before it. It would be a conflict of interest.